Morning, it's 10 a.m., October the 8th, 2013. My privilege to call the meeting of the Tennessee Department of Commerce and Insurance Board of Funeral Directors and Embalmers to order. I ask Ms. Lisa Mosby to call the roll, please.
Wayne Hinkle,
Here.
Tony Highsmith,
Here.
David Neal,
Here.
W.T. Patterson, Jane Gray Sowell, Robert Starkey,
Here.
Anita Taylor. Mr. President, we have four. We have a quorum.
Thank you, Ms. Mosby. I'd ask the board to please review the agenda for today's meeting.
Motion to adopt the agenda for today's meeting.
Second.
Motion made by Mr. Hinkle, seconded by Mr. Neal to adopt the agenda for today's meeting. All in favor, please say aye.
Aye.
Any opposed? Ask you at this time to please review the minutes from the August 13th, 2013 board meeting.
Motion to accept the minutes as presented.
Second.
Motion been made by Mr. Hinkle, seconded by Mr. Starkey to accept the minutes as presented. All in favor say aye.
Aye.
Any opposed? Next order of business on the agenda, we'll move to our legal report. Chair recognizes Mr. Bent McDonough, Assistant General Counsel, to give us our legal report.
Thank you very much, Mr. President. The first complaint is complaint number 2013-013641. Number 2 is complaint number 2013-013642. Number 3 is complaint number 2013-013643. Number 4 is complaint number 2013-013644. And number 5, excuse me, is complaint number 2013-013645. On July 11th, 2013, the board received a complaint supported by 6 various affidavits or depositions encompassing the 5 respondents referenced above. The complaint states that following a fire on April 17th, 2012, respondent number 1 continued to accept dead human bodies for cremation services with knowledge that the establishment lacked the proper refrigerated facilities to store the bodies, requiring proper refrigeration and not embalming. In response, the respondent states that they deny the allegations and aver that after the April 2012 fire, the respondents transported or caused to be transported dead human bodies which were to be cremated to other cremation establishments. After the fire, the bodies were sent to Phillips Robinson Memorial Crematory, Lawrence Funeral Home, and West Harpeth Crematory. For a time, respondent number 1 stacked boxes containing putrefied remains in a unrefrigerated back room at the establishment of respondent number 5. The respondent denies allegations that they stacked boxes containing putrefying remains in an unrefrigerated back room at the establishment of respondent number 5. The complaint also states that respondent number 5 had a refrigeration unit that only held 3 human bodies. For this reason, respondent number 1 had an employee to move stacks of boxes containing dead human bodies into a small building or barn where they remained for days, resulting in an overpowering stench of decomposing bodies. Respondents admit that respondent number 5 had a refrigeration unit that only held 3 human bodies. Respondent denies that any boxes of human bodies had ever been placed in the small building or barn at respondent number 5 for any reason other than for a period when a large cooler in an adjacent structure was used. Respondents also deny that they ever left bodies unrefrigerated for days, and without admitting the allegations of this complaint, respondents acknowledge that the bodies sometimes smell, dependent on the circumstances of death and the status of the decomposition upon arrival to the respondent's possession. The complainant also states that on occasion, respondent number 1 had employees place numerous boxes containing dead human bodies in stacks in a van for the purposes of hiding them from the state of Tennessee field representatives. Respondents admit that they do transport bodies in a van, and respondent specifically denies that they ever placed human bodies in stacks in a van for the purposes of hiding them from state field representatives. Respondents further deny that they have intentionally deceived state of Tennessee field representatives and deny remaining allegations in this paragraph. Respondent number 1 moved dead human bodies around on what employees called a church truck. As many as 6 or 7 boxes with stacked smoldering bodies were witnessed by one employee. Respondents deny any insinuation that was intended by the use of the term smoldering bodies. Also, the complainant claims that respondent number 1 routinely substituted cheaper merchandise for merchandise specified in pre-need contracts. Respondents deny this allegation and argue that if respondents provided the customer merchandise with which was different than the merchandise specified in the pre-need contract, that the respondent so advised the customer, obtained their consent, and provided like, kind, and quality merchandise to the consumer. The complainant also states that pre-need contracts often called for the purchase of Batesville brand caskets which are generally regarded as the best available. On behalf of respondents number 3 and number 4, respondent number 1 purchased and substituted less expensive Southern Craft brand caskets for the Batesville caskets without customers' knowledge, and then retained the difference in prices for their personal benefit. Respondents deny these allegations, specifically that they engaged in business practices intended to defraud consumers. Respondents do admit that they sometimes give customers caskets which are different than the casket designated in the pre-need contracts. However, they only do that with the consumer's consent. Respondents argue that they may offer different caskets of like kind and quality if the designated casket is discontinued or the casket company has gone out of business. Also, the family of the deceased may choose a different casket, and respondents specifically assert that if the family of the deceased chooses a less expensive casket, the family may choose to be given a refund for the difference in amount or credit to use towards other merchandise. No respondent retained any difference in price for their own personal benefit. Respondent number 1 is alleged to have cheated customers by using names for caskets that were ordinarily employed by Batesville, such as Primrose. Respondents deny the allegations that they have ever cheated their customers in any way. Respondents admit that they name and rename caskets as is customary in the industry. However, respondents specifically deny that they engage in any business practice intended to deceive their customers. Respondent number 1 is alleged to have ordered cheaper poplar caskets, painted them with cherry stain, and then sold them as though that they were the more expensive cherry wood models without revealing the difference in quality, price to the customers. Respondents deny that they ever painted or stained caskets for any reason. They are aware that some casket companies make caskets out of poplar wood, which is stained a cherry color by the manufacturer. Otherwise, respondent states that when a casket is displayed, a description of the material from which a casket is made is attached in accordance with the law. Respondent number 1 is alleged to have purchased inferior caskets from Tetrick in the Tri-Cities area of Tennessee, many of which were damaged and some of which had holes in the welds. Respondent number 1 had a body shop that they utilized to repair these damages, and cheaper caskets were substituted for more expensive models purchased by families. Respondents admit that they made a one-time purchase of caskets from Tetrick in the Tri-Cities area, but deny any of the caskets were damaged or had holes in the welds. Respondents specifically deny that they substituted these caskets for more expensive models purchased by the families. Pre-need contracts often called for the purchase of Wilbert brand vaults, a superior brand of vaults, or Monticello brand vaults within which to place the caskets. However, respondent number 1 purchased and substituted Eagle brand vaults for the more expensive vaults without customers' knowledge. The complainants also alleged that in order to carry out the scheme, respondent number 1 painted the cheaper vaults and placed liners in them to create the appearance of the more expensive and requested Wilbert brand vaults. Respondent number 1 would then retain the difference in costs under the pre-need contracts for the personal benefit. Respondents admit that pre-need contracts often call for the purchase of Wilbert brand vaults or Monticello vaults are always superior to all other brand vaults. Respondents deny that they purchased and substituted equal brand vaults for more expensive vaults without the customer's knowledge. The respondents admit that they sometimes give customers a vault which is different than the vault designated in the pre-need contract, but only with the consumer's consent, and they may offer a different vault of the like kind and quality if the designated vault is discontinued, the vault company has gone out of business, or the respondent no longer utilizes a particular company. Respondents deny ever placing liners in vaults and assert that if the family of the deceased chooses a less expensive vault, that the family may choose to be given a refund for the difference in the amount or a credit to use towards other merchandise. Furthermore, respondent number 1 never retained any difference in price for their personal benefit. Complaints allege that from 1996 through 2004, the Batesville operated a program called Total Casket Protection. Complaint states that this was a form of insurance intended to ensure a family of a decedent would have the particular casket they ordered, which often resulted in refunds at the time of the delivery, which were to be refunded to the purchasing family. However, respondent number 1 is alleged to have kept these refunds for personal benefit rather than tendering the money to the families. Respondents admit that Batesville did operate a program called Total Casket Protection, but they lack sufficient information to admit or deny when Batesville operated that program. The respondents deny that the program was a form of insurance intended to ensure that the family of a decedent would have the particular casket they ordered, and specifically deny that rebates were to be returned to the purchasing family. Respondents argue that the program was a consumer program for the funeral home, providing an incentive for the funeral homes to purchase Batesville caskets, and Batesville guaranteed that the funeral home would get the casket at the time of need or for the same amount listed on the pre-need contract. On multiple occasions, respondent number 1 is alleged to have accepted checks as payment for funerals, endorsed the checks, and then wrote off the amounts as bad debts without placing the funds in a trust so that they would be available when at the time that the funds were needed. Respondents deny that respondent number 1 accepted checks as payment for funerals, endorsed the checks, and then wrote off the amounts as bad debt without placing the funds in a pre-need trust so that the funds would be available for future need. Respondent 1 is alleged to have instructed employees to place cash payments for services in an envelope and place that envelope in the respondent's desk drawer. Respondents deny that respondent number 1 instructed employees to place cash payments for services in an envelope and place that envelope in the respondent's desk drawer. The respondent number 1 is also alleged to have pocketed funds for funerals without placing them in the establishment account and marking them off as bad debt. Respondents deny respondent number 1 pocketed funds for funerals without placing them in the establishment account and marking them off as bad debt. Specifically, they deny it is a business practice to place money in the respondent's desk drawer. Respondent number 1 is alleged to have converted consumers' refunds from pre-need contracts for respondent's personal benefit rather than refund the customer's money. The prices on the date of death are those charged under pre-need contracts. When the funds invested under a pre-need contract yielded a return greater than the fair market value of the items and services purchased to be rendered under the contract, respondent number 1 simply increased the cost in order to keep all the money. The respondents deny that respondent number 1 converted consumers' refunds from pre-need contracts for respondent's personal benefit rather than refund the consumer's money. Respondent number 1 is alleged to have sent fraudulent documents to Forethought via interstate wire transfer. Respondent did so for the purpose of deceiving consumers and depriving families of the refunds to which they were entitled. Respondents deny that respondent number 1 sent fraudulent documents to Forethought. Specifically, respondents deny that they converted consumers' refunds from pre-need contracts for the benefit of the respondents or that they used any tactics to trick their customers. Respondents argue that the consumers are given a refund when the funds invested under a pre-need contract yield a return greater than the current general price list for the items purchased and services to be rendered under the contract. Respondents further assert that they sold merchandise for the price listed in the general price list, which is regulated by the federal disclosure requirements. Respondents deny respondent number 1 sent fraudulent documents to Forethought, and specifically that the respondents deny that they created or forwarded any fraudulent documents, utilized wire transfers, or engaged in deceitful business practices. On one occasion, respondent number 1 is alleged to have accepted a restored 1951 Ford motor vehicle with an estimated value of between $20,000 and $25,000 as a payment in kind from a husband and wife for their funerals. No funeral funds were placed in trust for these pre-need funerals. The purported price of the 2 funerals was far less than the estimated value of the motor vehicle. 2 contracts were drafted for the funerals, and the charges were charged off as a bad debt. The respondents admit that the respondent number 1 did accept a restored 1951 Ford motor vehicle, but never had the car appraised, and therefore neither admit nor deny the allegation as to the vehicle's value. Respondents argue that the husband and wife were the grandparents of respondent number 1, respondent's wife, who were concerned about paying for the funeral and asked respondent number 1 if he would take the car as payment. Also, the grandparents asked that the car be used in their funerals, and respondent number 1 agreed to take the car in exchange for 2 funerals as a favor to his family. Respondent number 1 took possession of the car and executed a sworn statement stating that the couple's funerals would be paid in full, and funds could not have been placed in the trust because respondent number 1 never sold the car, as he was saving it to use in the funerals, and no funds exchanged hands. Respondents deny the charge of the funerals being written off as bad debt, and respondent number 1 stored the car for years and has since returned the car to the family. When a competing funeral home generously provided additional space to the respondents for the embalming purposes after the April 17, 2012 fire, the complainants alleged that an assistant of respondent number 1 solicited business from a grieving family on the premises of the generous funeral home on the same day that they brought their deceased loved one to that establishment for services. Respondents admit that a competing funeral home generously provided respondents additional space for embalming purposes after the fire on April 17, 2012, but deny that any of the employees solicited business from a grieving family on the premises of that establishment. Respondents argue that the manager of respondent number 3 received a call from a price shopper who inquired about funeral services and prices. As requested, the manager met the family at the location of respondent number 5, where they discovered that the family had also contacted the competing funeral establishment. Respondents deny solicitation of any kind took place in this matter. Next, respondent number 1 is alleged to have knowingly submitted falsified apprenticeship forms to the state of Tennessee on behalf of the respondent's daughter. These falsified documents included quarterly reports and records of time not actually spent with the daughter's sponsor. Respondents deny that respondent number 1 knowingly submitted false apprenticeship forms to the state of Tennessee on behalf of the respondent's daughter. The complainant who provided this information worked primarily as an embalmer at the respondent establishment and waited on very few families during the time that these allegations are alleged to have taken place. The daughter of respondent number 1 worked primarily under respondent number 1 and the manager of the establishment rather than with this particular complainant. Next, the respondent number 1 is alleged to have customarily purchased soft drinks from Sam's. He then filled the establishment vending machines with these drinks and tripled the price for sale to the establishment customers and guests. Respondent number 1 routinely took the money from the vending machine and converted coins into paper money, kept all the proceeds for their personal benefit, and never reported the income for sales tax purposes. The respondents argue that they admit that respondent number 1 purchased soft drinks from Sam's Club and filled vending machines with these drinks. However, respondents deny that they tripled the price. Respondents assert that the soft drink machine was itself purchased from Sam's Club along with the drinks, and respondents admit that they did not report the income for sales tax purposes, but deny that they were required to do so by law. Next, after respondent number 1 allegedly accused the complainant of violating a non-compete agreement, respondent number 1 instructed an agent of respondent number 5 to attend the May 8, 2013 burial services where complainant was to say a prayer as previously expressly requested by the deceased. This agent for respondent number 1 took a photograph of the complainant just as the mourning family bowed their heads to pray and just before a family member was to read a passage. The family members witnessed this profoundly disrespectful conduct, and the decedent's husband cries every night because of what occurred at his beloved wife's funeral. Respondents admit that they filed suit against the main complainant, in this case for violating a non-compete agreement. Respondents deny that they instructed an agent of respondent number 5 to attend the May 8, 2013 burial services, and respondents argue that an agent of respondent number 5 always attends services which occur at the cemetery. In this case, we found a history for respondent number 1 of 1 closed complaint. Respondent number 2, no prior complaints. Respondent number 3, 1 dismissed complaint and 10 closed complaints. Respondent number 4, 1 closed complaint. And respondent number 5, 1 closed complaint and 1 open complaint. And we're recommending that these 5 cases be sent for further investigation in this matter.
What does that mean, further investigation? They would turn it over to,
We'd like to send one of our field representatives out to investigate the matter further and to look into these allegations and responses.
Motion to accept council's recommendation.
second.
Motion has been made by Mr. Hinkle, seconded by Mr. Starkey, to accept council's recommendation to refer these 26 complaints for further investigation by this office, one of our field representatives. Is there any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Thank you, Benton, for that lengthy report. That's tough.
Appreciate that. Number 6 is case number 2013-014761. Number 7 is case 2013-014762. And number 8 is case 2013-014763. On June 5th, 2013, a field representative conducted a routine inspection of respondent number 7. In this case, the funeral director's license of respondent number 6 expired on March 31st, 2013, and was not renewed until May 15th of 2013. Also during that time, respondent number 6 acted in the capacity of funeral director on at least 3 funeral cases, and respondent number 6 was listed as a funeral director in all 3 cases. Respondent number 6 signed the statement of funeral goods and services selected in the capacity of a licensed funeral director in all 3 cases, and respondent number 6 also signed 1 cremation authorization form in the capacity of a licensed funeral director. Also, we just determined that the embalmer's license of respondent number 6 expired on March 31st, 2013, and was not renewed until May 15th, 2013. However, no evidence was presented showing that respondent number 6 ever embalmed a body during that time. As for respondent number 7, the funeral director's license of respondent number 6 expired on March 31st, 2013, was not renewed until May 15th, 2013. During that time, the respondent number 6 acted in the capacity of funeral director while employed by respondent number 7, and respondent number 6 was the funeral director of record for the family of 1 deceased individual. As for respondent number 8, the field representative conducted a routine inspection of the respondent's establishment on June 4th, 2013. It was determined that the funeral director's license for respondent number 6 expired on March 31st, 2013, and was not renewed until May 15th, 2013. During that time, respondent number 6 acted in the capacity of funeral director while employed at respondent number 8, and respondent number 6 was the funeral director of record for 2 families who selected respondent number 8 to conduct funeral or cremation services for their deceased family members. In response, respondent number 6 states that they were living away from their home and their spouse during that time. Also during that time, the wife of respondent number 6 failed to inform him of the fact that his license renewal forms arrived at the house during his absence, and therefore he was practicing on an expired license and did not reinstate his license until May 15th of 2013. We found no history of complaints for respondent number 6, number 7. However, for number 8, we found a history of 2 dismissed complaints, 7 closed complaints, and 1 complaint that is currently open. In this case, we're recommending a consent order of $250 and authorization for a hearing for respondent number 6, also for respondent number 7, and also for respondent number 8.
Make a motion to accept council's recommendation.
Second.
Motion is made by Mr. Starkey and seconded by Mr. Neal to accept council's recommendation. Is there any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 9 is case 2013-016-771, and number 10 is case 2013-016-772. This complaint was filed on August 27, 2013, and pertained to incidents that transpired since changes occurred within the establishment. The complainant has issues with the former owner and his establishment talking to other businesses, citizens, and clients that the complainant has serviced since his departure. Based upon those discussions, the complainant states that 3 complaints have since been filed against their establishment. The complainant has concerns with pre-need issues, and since entering into business with the past owner in 2008, they've had numerous pre-needs transferred from his previous business to the complainant's new establishment. With these transfers came many problems. No money was transferred with the majority of these cases, and there were many instances where the pre-need accounts were not properly handled. The client's money was taken, but no pre-need was filed, and no money was put into trust. The complainant states that their business has suffered due to the respondent's poor business practices. After informing one client of the problems with her aunt's pre-need contract, she made a contract with the respondent and decided to transfer her business to his new establishment after speaking with him. The problem with this is that the services had already taken place in regards to this individual's loved one, whose aunt was already removed, transferred to the complainant's establishment, and placed in a corrugated container and cremated. Another family member received the remains of their loved one and proceeded to have a memorial service at the respondent's new funeral establishment. Complainant was not Complainant was not paid for the services rendered to this family from the respondent. The respondent's employees stated that the respondent wrote up the consumer's pre-need contract in 2007, took money from the pre-need paid by the consumer, and never filed the pre-need paperwork and never put money into the trust. No pre-need contract existed according to this employee, and all communication was ceased on the part with the complainant's establishment. The complainant states that their establishment has already taken many hits from the state due to the previous owner's poor business practices. The complainant states that they do not know who will walk into their establishment next and claim to have a contract with the establishment or the previous owner's business. The respondent has made statements to other establishments that they will see to it that the complainant's business is shut down. In response, respondent states that they are aware that respondent number 9 sent a letter to Robert Gribble asking that the complainant be prevented from inappropriately using the name of respondent number 9 as it relates to consumers, businesses, and others. Respondent is not knowledgeable and unable to address any problems concerning statements as to the pre-needs that respondent number 9 or his employees would have written. The respondent believes that these statements supporting these allegations are just hearsay, and that the people saying these things should appear and acknowledge their statements. Respondent would like to point out that the author of the complainant notarized his own statement and therefore believes that the complaint should be considered void. In this case, we found a history of 1 closed complaint against respondent number 9 and nothing for 10, and our recommendation is to dismiss the complaints against respondent number 9 and number 10, is that this is an issue between former business partners and may be better addressed through the civil court system.
Make a motion, we accept council's recommendation.
Second.
Motion has been made by Mr. Neal, seconded by Mr. Hinkle to accept council's recommendation. Is there any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 11 is case 2013-016-781. Number 12 is case 2013-016-782. This complaint was filed on August 27, 2013, and pertained to incidents that transpired since changes occurred within the establishment. Complainant has had issues with the former owner and his establishment, talking to other businesses, citizens, and clients that the complainant has serviced since his departure. Based upon those discussions, the complainant states that 3 complaints have been filed against their establishment. The complainant has concerns with pre-need issues, and since entering into business with the previous owner in 2008, they have had numerous pre-needs transferred from the previous business to the complainant's new establishment. With these transfers came many problems. No money was ever transferred with the majority of these cases. There were many instances where the pre-need accounts were not properly handled. The client's money was taken, but no pre-need contract was filed and no money was put into trust. Complainant states that their business has suffered due to the respondent's poor business practices. After informing one client of the problems with her aunt's pre-need contract, she entered into a contract with the respondent and decided to transfer her business to his new establishment after speaking with him. Complainant states that the problem with this is that the services had already taken place in regards to her loved one. The aunt was already removed, transferred to the complainant's establishment, placed in a corrugated container, and cremated. Another family member received the remains of their loved one and proceeded to have a memorial service at the respondent's new funeral establishment. The complainant was not paid for the services rendered to his family from the respondent. The respondent's employees stated that the respondent wrote up consumers' pre-need contracts in 2007, took money from the pre-need contract paid by the consumer, never filed the pre-need paperwork, and never put money in trust. The complainant states that no pre-need contract existed according to this employee and that all communication was ceased on the part of the complainant's establishment. Complainant states that their establishment has already taken many hits from the state due to this previous owner's poor business practices. The complainant states that they do not know who will walk into their establishment next and claim to have the contract with the establishment or the previous owner's business. The respondent made statements to other establishments that they will see to it that the complainant's business is shut down. In this particular complaint, we received no response from the respondent, and for respondent number 11, we found a history of 3 closed complaints and 1 dismissed complaint. And respondent number 12, we found 14 closed complaints and 1 dismissed complaint, and also 2 open complaints. And for respondent number 11, we're recommending a consent order for $250 with a $250 civil penalty for failure to respond and authorization for a hearing. And respondent number 12, we're recommending a consent order with a $250 civil penalty for failure to respond and authorization for a hearing.
Is that the same case that you sent back before?
The last 4 that we've had just now have been filed by the same complainants, but we've had to treat them as separate instances. So that's why I had to basically reread you the previous complaint matter.
It's also separate respondents. They're related, but they're separate.
11 and 12 did not respond.
That's correct.
Motion to accept council's recommendation.
Was there no other penalty except just because they did not respond? Is that correct?
Right. Otherwise, we would have probably recommended that it be dismissed because it's pretty much related to the previous one where it's just a business relationship. So.
Second.
Motion has been made by Mr. Hinkle, seconded by Mr. Neal. Send over $250 civil penalty for failure to respond as recommended by legal counsel. Is there any further discussion? All in favor say aye. Aye. Any opposed? Motion carries.
Number 13 is case 2013-017481. Excuse me. A consumer complainant states that a consumer recently appeared at the complainant's place of business to check on the status of a pre-need direct cremation arrangements that they made in December of 2008. The consumer presented a complainant with a paid cash receipt in the amount of $1,515 signed by the respondent. Also, a statement of funeral goods and services selected, a change of policy certificate annuity ownership to the Forethought Trust form, and group enrollment form to Forethought. The consumer advised that at the time of the pre-need arrangements that she paid cash to the respondent, who then folded the money and placed it in his pants pocket. The complainant has no record whatsoever of this transaction and confirmed with the consumer that She had not received any policy information in the mail from Forethought Life Insurance Company. The complainant contacted Forethought and other carriers utilized by it during this time and again found no record of this transaction taking place. The complainant acknowledged that the payment made directly to the respondent and had been paid directly to the respondent and committed to honor the contract that the consumer brought to their attention. In response, the consumer appeared at the complainant funeral home in December of 2008 and paid cash in the amount of $1,515 for pre-need direct cremation arrangements. The cash was delivered to the respondent, who then drafted and provided the consumer a paid cash receipt, a statement of funeral goods and services selected, a change of policy, certificate of annuity, ownership to the Forethought trust form, and also the group enrollment form for Forethought. Respondent denies any allegation, insinuation, or accusation that he acted illegally, inappropriately, or in a manner unbecoming of the profession in any manner whatsoever. The complainant fails to actually accuse respondent of anything illegal taking place according to the respondent. The complainant is vague and ambiguous and leaves it unclear as to what is being alleged, who the complainant is blaming for the apparent failure to properly store records and comply with the applicable laws and regulations. Respondent states that the complaint only states that the complainant believes it is appropriate to report this matter to the board because respondent was involved in the transaction, merely insinuating and leaving it to the imagination of the reader to conclude that the respondent has done something improper. The complainant is just as likely responsible for these actions, and respondent states that one may easily conclude that the respondent delivered the cash and documentation to the owner as he was instructed to do, and that the owner failed to process the pre-need order and cash and properly file the documentation. Also, respondent states that there is no express allegation in this complaint and that it was standard business practice at the complainant's establishment during respondent's employment to do exactly what is described in the complaint as far as drafting documents and accepting cash from clients. Respondent states that they were then instructed to deliver the contracts and cash directly to the owner and that he was advised that the owner would take care of it from there. Whether the owner properly processed and stored the documentation and deposited the cash from the point of delivery is unknown at this time. Respondent states that complainant is to blame for the failure to properly file the pre-need paperwork, not the respondent. Respondent created and executed all necessary documents and provided copies of them to the consumer, just as he was supposed to do. The complaint states that only that the complainant does not have a record of the transaction at this time, but does not affirmatively state that respondent failed to ever provide a record or the cash to the owner at any time. What the owner did with the documents and cash and why he failed to process them or invest the cash is left for the owner to explain. Acceptance of cash for services was common practice and openly encouraged. When the owner first hired respondent, the first thing the owner told the respondent was that checks are fine, but cash is divine. The owner would routinely come to the respondent and tell him that he needed cash and that he did not care how he got it. Had respondent not provided the appropriate paperwork to the consumer, it may have been more difficult to convince complainant to uphold his end of the contract. To the extent that the complainant communicated any of the false allegations now asserted against the respondent in this complaint, the complainant is possibly liable for slander and tortious interference with prospective business relationships, but those allegations are outside the jurisdiction of this board. Respondent denies all the allegations improperly and respectfully requests that the complaint be dismissed immediately. In this case, we found 2 closed complaints and 1 open complaint, and this one we are recommending that it be referred for further investigation.
Motion to accept council's recommendation.
Second.
Motion has been made by Mr. Hinkle, seconded by Mr. Starkey, to refer this complaint for further investigation at council's recommendation. Is there any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Number 14 is case 2013-012051. On May 1st, 2013, a field representative conducted a routine inspection of the respondent establishment. It was determined that the respondent failed to itemize all individual goods and services purchased on one statement of funeral goods and services selected, on a statement of funeral goods and services selected, and that this occurred on 4 separate occasions for the consumers of Shirley Harvey, Deborah Wilhoit, Warren Essex, and William Charles Zimmerman Sr. Also, during the inspection, it was determined that the crematory fee is a cash advance to the provider and should be listed as such on the statement of funeral goods and services selected, except when direct cremation is purchased. This provider fails to put the crematory fee in a cash advance, listing it instead as a $350 charge on the services side and listing it as a cremation charge service. Furthermore, the respondent fails to list the direct cremation as such on the statement of funeral goods and services selected when direct cremation is purchased. In response, the respondent states that the complaint requires that the respondent provide an itemized list of all the individual goods and services purchased together with the price of each item, and respondent claims that their contracts do in fact provide that information. The respondent states that each specific good and or service selected is individually listed and identified. Respondent states that the space was limited and therefore the services and their prices were listed on separate attachments. Neither the funeral rule nor the board rules or statutes require any specific format regarding statements of funeral goods and services selected, nor do they require that prices and descriptions be listed on the first page. The respondent states that each good or service selected by the consumer is listed separately together with a price for each individual good or service. Furthermore, the respondent states that the field representative stated that the crematory fee is a cash advance item to this establishment except for direct cremations. The respondent states that the money paid to the respondent for cremation is not an accommodation, cash disbursement, or payment for any item obtained from a third party. Rather, the crematory utilized is a crematory owned and operated by the same entity that owns and operates the respondent establishment. As such, the charge for a cremation is identified on the general price list, not as a cash advance item, but as a charge by the respondent for the use of their crematory. The money is not passed through or paid to any third party, and as for direct cremations, respondent states that there is no requirement or regulation which requires the exact phrasing of direct cremation on the statement, and that the respondent denotes cremations by the phrasing of cremation charge. In this case, we found a history of one closed complaint, and we're recommending a letter of warning in this case.
Make a motion, we accept council's recommendation.
Second.
Motion is made by Mr. Neal, second by Mr. Hinkle to accept council's recommendation. Any further discussion?
I'd like to ask something.
Go right ahead.
We're sending a letter of warning, and their response was that this board or none of the rules require any specific format regarding the SFGSS. What would we be saying in our letter of warning?
I think in this situation, the letter of warning is probably aimed more towards the fact that as far as the format on their statement of funeral goods and services selected, and with the case of the 4 individuals where the pricing wasn't on the first page, while it's not required to be on there, it's just, I think, making them aware that they probably need to make it clear for the consumer to be able to read those documents and those contracts once they pay for the funeral, to cover the funeral in that case.
I've always been told, and maybe, I don't know, this is a little contradictory here. If you charge, it's kind of like buying a Wilbur vault. You have the funeral home price, and then you have Wilbur, what you pay for it. But a lot of people, if you go to a independent third-party cremation, you know, as long as you, and they charge X dollars, but you charge more, if you itemize it on the funeral home side, you know, that's legal. If you pay exactly what they're charging, you put it in cash advances, you know. So some people put a fee on top of what the crematory, in other words, the crematory charges like a wholesale price.
Right.
So is that correct? That's either way is legal depending on which way you're doing it, right?
Not so sure that is a correct statement, that cremation fee has to be itemized as a cash advance in any circumstance other than a direct cremation. I don't think that's a correct statement.
don't either.
I could be educated along those lines, but I don't think that's a correct statement.
They still fail to do this. I mean, that's undisputable.
Charge is included in our cremation charge.
My understanding, anyway.
As I stated before, though, I think it's appropriate in this case to issue a letter of warning for the four contracts that were stated earlier, where they failed to itemize all the individual goods and services purchased on the statement of funeral goods and services selected. I mean, I think where we're coming from is that they didn't appear very clear on there as far as the itemized prices, that it probably wasn't, if it wasn't clear to our field representative, then I doubt it would be clear to a consumer that's coming in to purchase from that establishment. So that was our purpose for the letter of warning in this case, and just to let them know that that's probably something that they need to address.
I still don't understand where the field representative states the crematory fee is a cash advance item to this establishment except for direct cremation. I mean, you have direct cremation theoretically with a memorial service, direct cremation with a, you know, I've never seen where cremation is a cash advance item. Funeral home perspective, you know.
As I stated before, the letter of warning is mainly pertaining to the issue for the itemization on the statement of funeral goods and services selected, not the, I think that's more what we're worried about, is the itemization on the statement of funeral goods and services selected, not the direct cremation issue that you're addressing now. We're more concerned about the four statements of funeral goods and services selected where the itemization wasn't clear on there, not the cash advance so much.
Yeah, but if the field representative comes in and says you're supposed to have that as a cash advance, you know, what's your argument? I've never put it as a cash advance. Of course, it's always included in my direct cremation charge.
That's not something that's going to be addressed in the letter of warning. This is specifically regarding the four statements of funeral goods and services selected where the itemization wasn't so clear, and the issue with the direct cremation isn't so much relevant to the letter of warning that we're going to issue at this time.
Any other discussion? Ms. Mosby, the record does reflect that in item 14 has been properly motion made, seconded, and passed. And this discussion was, okay, this was in discussion, okay. So,
Discussion.
We have a motion on the floor by who, Ms. Mosby?
Motion was made by David Neal. The second was by Mr. Wayne Hinkle.
And we had discussion after that. Now we're ready. Any other discussion? Thank you, Ms. Mosby. All in favor, say aye. Aye. Any opposed? Motion carries.
Number 15 is case 2013-014-051. The complainant states that she and her husband had agreed that when he passed away that his body would not be embalmed. The decedent passed away on May 1st, 2013, and the complainant began planning his funeral on May 2nd, 2013. However, she received a call from the respondent that they had picked the body up from the hospital the day before. The complainant informed the respondent that he had possession of the body by mistake and that she wanted to go to a different funeral establishment. The complainant states that the respondent then became hostile and started asking her who would pay for the embalming that already took place. The complainant was upset and called the funeral board who recommended that she have the local police escort her to the respondent's funeral establishment to remove the body. The complainant is upset by her mistreatment at the hands of the respondent and has suffered from depression and other issues since finding out that her husband was improperly embalmed. We received no response in this case, and we found a history of 14 closed complaints, 1 dismissed complaint, and 1 open complaint. And in this case, we're recommending that the establishment license be suspended for 3 months and authorization for a hearing. That a consent order be offered for a suspension of the establishment license for 3 months and authorization for a hearing.
Stick $250 in there too?
I'll
They didn't
respond
respond, did they?
If the board sees that as appropriate.
then. I would think so.
If you're not gonna respond, then that's a penalty too. I'm gonna make a motion to accept council's recommendation and amend it to add $250 civil penalty. It is a civil penalty, isn't it,
Yes, sir.
for non-response?
Second.
Okay, we have a motion by Mr. Hinkle, a second by Mr. Neal, to accept council's recommendation of a suspended establishment license for 3 months, authorization for a hearing, and $250 civil penalty. Under further discussion, respondent received the body or took custody of the body by mistake. Am I reading that correctly?
That's correct.
The respondent apparently embalmed the body without permission. Correct?
That's also correct.
The complainant wanted to use another funeral establishment, and there is where the hostility began to take place, correct?
Correct.
Pretty lengthy history of other complaints regarding unprofessional conduct, misrepresentation and fraud, pricing violations, harassment. Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Number 16 is case 2013-014-351, which is an unlicensed establishment. Number 17 is case 2013-014-352. And number 18 is case 2013-014-353. On Saturday, July 20th, 2013, a field representative saw a sign stating that the respondent funeral establishment was opening and a dedication service was to commence at 5 o'clock that evening. The building looked like a church or funeral home, and there was a funeral hearse parked outside. Upon entering the building, they were met by a couple at the front door who introduced themselves as the owners. The field representative told them that they thought the business was an auto repair parts store, and that the owners informed them that the business had moved down the street and that this facility was now a funeral establishment. The owner asked if they wanted to take a tour of the establishment. The owner had graduated from the John A. Gupton College and was also a minister. The respondent had added that his wife was from that local town, and so they decided to open up a new location there. And while touring the facility, the field representative noticed that there was an office area, a family area, and a chapel. Upon entering the chapel, the field representative noticed 3 adult caskets and 1 infant casket. The owner stated that they were for sale, and he was asked if he had a price list, and he stated that he had no general price list, but guaranteed his prices were cheaper than any funeral home around that area. Also, the field rep asked the representative where bodies would be prepared, and the field rep and the respondent stated that he had another location where he would prepare the bodies. There was an apprentice embalmer's license and apprentice funeral director's license on the wall, and the respondent thanked the field representative for stopping by. And upon checking with the board, there appears to have been no establishment license issued for this location, nor anything but an apprentice license issued for this individual. In response, the respondent states that he has no recollection of this conversation with the field representative. The location is a diverse service center suited for a venue for all life events such as weddings, funerals, baby showers, and other life events. Respondent states that he has contacted the local funeral homes and made mention to the licensed owners of the establishments that in certain cases they are more than welcome to use this venue for funeral and memorial services locally. Because there isn't a funeral parlor in town, the respondent states that this can cut back on the amount of travel for families and funeral directors. The proposed content of a letter sent out by the respondent to the public makes mention about having contracts with having contracts with licensed morticians to which families can be referred, noting that they have made contact with local funeral homes and that their facility, they're willing to provide services to the families at their time of need. Respondent states that the above complaint also bears witness to no general price list because respondent is not a funeral home establishment, nor do they operate or advertise as such. Respondent states that they are there to service local families with an event venue setting that is comfortable and elegant. We found no prior complaints for respondents number 16, 17, or 18, and in this case, we're recommending a $1,000 civil penalty and authorization for a hearing for each individual respondent 16, 17, and 18.
Do they have any signage in front of this facility?
They did.
Does it state funeral home on the signage?
It doesn't state funeral home.
It had a hearse in front of it,
That's correct.
which we didn't. It had 2 apprentice license hanging on the wall.
They don't have an establishment license.
That's correct. And the sign did have the word chapel in it, but that was the extent of it. It did not have a funeral home or
Memorial Chapel?
I did not have memorial chapel.
And in that chapel, we had caskets for sale.
That's correct.
We had no GPL, but we were cheaper than anybody else in town.
Any funeral home around. Then he says, oh, this is for the other funeral homes around.
I wonder if they realized those were field representatives they were talking to. I'm sure the guys identified themselves. Motion to accept council's recommendation.
Is there any way to close a place like that? I mean, they haven't gone through any.
Inspection or anything?
Not at the moment. They haven't.
We can't pull their establishment license. We can't pull the apprentice license or certificates. Make my recommendation based on, let's see what happens.
Well, if they don't respond back, they don't pay the civil penalty if we go through with this, then what's the next action?
Next, we would have a formal hearing if they decide not to
show up for that.
respond. And then if they, they don't respond to that, at that point, we would probably turn it over to the Attorney General's office and let them handle the matter.
So we could not issue a cease and desist order until they're properly licensed?
No, I think we can in this case, if that's something that you all feel is,
Absolutely.
as far as any sort of funeral services that they're providing.
Well, the fact that he said we beat any funeral home around, that kind of opens the door
Yeah.
of the indication. Then he states, well, we're just actually for weddings. Yeah.
A motion on the floor to accept council's recommendation at this point, which is consent order, $1,000 civil penalty and authorization for a hearing on all three respondents. Is there a second to that motion? Motion fails for lack of second.
Okay, do we make the recommendation at this point that they cease and desist order?
This is still open for discussion. Yes. Is there any other discussion?
I make a motion for a cease and desist order in conjunction with a $1,000 penalty and the thing.
A motion on the floor to accept council's recommendation of consent order, $1,000 penalty with authorization for a hearing, and also the issuance of a cease and desist order in conjunction with that for all three respondents. Is there a second?
Second.
Motion is made by Mr. Starkey and seconded by Mr. Neals. Any further discussion? All in favor, say aye. Motion carries.
Number 19 is case 2013014-701. On July 17th, 2013, a field representative conducted a routine inspection of the respondent establishment. As far as the casket price list, the titling used on the casket price list does not comply as directed and must be corrected to read casket price list. On the outer burial container price list, the titling used on the outer burial container price list does not comply as directed and must be corrected to read outer burial container price list. Also on the casket price list, in the casket selection room, one casket being offered to the consumer is listed at a price that is inconsistent with the price on the casket price list. The casket is the Roman 18-gauge steel. On the unit, the price in the casket selection room is $3,000, but the casket price list has it for $3,250. Also in the preparation room, the preparation room is in need of a general overall cleaning. They found soiled linen towels in plain view in several areas of the room. No soiled linen container with non-porous bag in the preparation room. Also clean sheets piled on the dirty floor that should have been put away. A garbage bag full of garbage was in the floor instead of in the garbage can. The garbage container was full and in need of emptying, and the cosmetics from the last embalming left uncovered on the floor were not put away. According to staff, the previous embalming was performed by this establishment on the previous Friday, June 12, 2013, and the inspection took place on that Thursday, July 17, 2013. Also, description of funeral merchandise in the casket selection room. 3 units did not have any information on the exterior of the container as required by law, and those were the Madison 18-gauge steel, the Going Home 18-gauge steel, and the Jessup 20-gauge steel. In response, the respondent states that they've corrected the casket price list and outer burial container price list. Respondent states that the typist corrected a $250 typo that was on the list as well. As far as the preparation room, the respondent corrected the findings and has since implemented checks and balances for the preparation room, including to check prior to cases coming into the preparation room, check after cases exit the preparation room. Checklist is on the wall of the preparation room. The linen closet has been placed in the preparation room for clean sheets. Another container labeled hazard has been placed in the preparation room. Cosmetics cases, Those are on the checkoff list, and no full garbage bags are in the preparation room. As for the description of the funeral merchandise, respondent states that management has implemented additional checks and balances on checking each and every casket that arrives in the funeral home. Respondent states that funeral home will not accept any casket without labels on the casket, and that respondent corrected the problems, and they have since received labels and placed them on all 3 caskets. We found a history of 1 closed complaint in this case, and we're recommending a consent order with a $250 civil penalty and authorization for a hearing.
Make a motion, we accept council's recommendation.
Second.
Motion made, Mr. Starkey, second, Mr. Hinkle, to accept council's recommendations. Any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 20 is case 2013-014771. On July 24th, 2013, a field representative conducted a routine inspection of the respondent establishment. They found a failure to maintain separate records containing the location of release, date of release, and the manner of final disposition of cremated remains. The same violation was found at the last inspection on December 6, 2012. A document presented was titled Cremation Disposition Log, and it failed to contain the date of the release, location, and manner of the final disposition by the crematory. This required information also does not appear on the crematory log. Additionally, the document titled Cremation Disposition Log has no entry since May 2nd, 2013, more than 2.5 months prior to this inspection. Also, a copy of the funeral director's license required by this statute for the crematory operator was not available at the establishment during the inspection. The apprentice funeral director certificate was available but had expired on June 30th, 2013. The crematory operator stated that he had made a phone call to another location during the inspection, and a copy of his current funeral director's license was faxed to an office in the cemetery maintenance building adjacent to the respondent establishment. Additionally, a copy of a funeral director's license available at the crematory for another crematory operator expired on June 30th of 2013. And the other operator stated that he made a phone call and obtained the other individual's current funeral director's license as well. In response, respondent states that they would state that the log is, in fact, deficient, as it did not include the date of release as required by law. The shortcoming in the cremation disposition log has since been rectified by the respondent. As for the location of release, respondent states that all cremains are released from the crematory itself. Despite this, respondent will now include a separate column on its cremation disposition log for location of release. As for the manner of final disposition, respondent would contend that the cremation disposition log did, in fact, include this information in the column labeled disposition. It was also understood by respondent that the field representative had previously indicated that this method of reporting the final disposition was satisfactory. It was also noted that the logbook had not been updated since May 2nd, 2013, but at the time of the inspection, the log was being restored due to water damage caused by a leaking air conditioning unit. The cremation disposition log is now completely restored and up to date and available for inspection. Furthermore, respondent states that they provided up-to-date licenses for all the crematory operators, which are now currently posted at the establishment and are available for inspection. We found a history of 1 closed complaint and 1 open complaint in this matter, and we're recommending a consent order with a $1,000 civil penalty and authorization for a hearing.
Isn't that kind of penalty a little high based on some of the others, or is that, am I missing something here?
They had other findings against them at a previous location, and in that situation, there was a $500 civil penalty in that case. And I know that in this situation, they were written up for a repeat violation in that. So that's the purpose of the $1,000 civil penalty.
Okay.
We still have 1 open complaint.
Yes.
It was found in December 6, 2012, and was found again on July 24th, 2013. Motion to accept council's recommendation.
Second.
Motion is made by Mr. Hinkle, seconded by Mr. Starkey to accept council's recommendation. All in favor, say aye. Any opposed? Motion carries.
Number 20. For 21 is case 2013014841. A field representative was driving near his home one day and witnessed a sign which read the name of the respondent establishment. The field representative found this odd due to the fact that no building currently existed on that property. The field representative found no application was submitted to the board, nor does the board have knowledge of existence of the establishment opening a location in the future. The establishment does have a website already operating and linked to a local cemetery. In response, respondent states that it is unclear to respondent how this sign violates any of the rules referenced in the complaint. Since funeral services are not being offered, nor is there even a building completed which would be open to the public, it is unclear how that may be construed as deceptive or misleading to the public. The sign noticed in passing was put in place by the construction company to identify the construction project. We found no history of prior complaints, and we're recommending a letter of warning in this case.
Make a recommendation, we accept council's.
Second.
Motion is made by Mr. Starkey to accept council's recommendation, seconded by Mr. Hinkle. Is any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Number 22 is case 2013015511. The complainant took issue with his name still being used and information being falsely communicated to consumers and businesses by the respondent, who knows that the complainant is no longer a part of the establishment. Consumers and businesses have contacted complainant with various complaints of his name being improperly used for death calls. Complainant has referred several individuals to the board with directives for them to file a formal complaint. The complainant does know that the manager continues to instruct, make service arrangements using the complainant's name. The manager informs consumers if a death call is received that the complainant is either on vacation, away from the office, or communicates to them that the complainant told this person to handle the case. The complainant would not instruct the manager or any other person who is not licensed, who's not a licensed funeral director, to make arrangements regarding a service. In response, respondent states that complainant's name is not used on any literature, contracts, marketing, advertising material, verbally, or with contracted answering services. Notice was given to the board in writing that the complainant is now affiliated with another funeral home and is no longer a part of, nor does he represent, conduct business with, nor is he any longer affiliated with the respondent. Respondent submitted an application for name change and was ultimately accepted and approved. No individual is acting as a licensed funeral director without being properly licensed. A licensed funeral director is present to provide services. If anyone calls the respondent asking to speak to the complainant, they are informed that the complainant no longer works with the respondent, and no one has ever claimed that the respondent is on vacation or out of the office. We found a history of 2 closed complaints and 6 open complaints, and we're recommending that this case be dismissed as this is an issue between former business partners.
Motion to accept council's recommendation.
Second.
Motion made by Mr. Hinkle, seconded by Mr. Starkey to accept council's recommendation to dismiss this complaint. All in favor, any other discussion?
How long does it take to close a complaint? Some of these go back to 2010, it shows on here.
Some of those matters have been referred to litigation if a person doesn't respond within 30 days after receiving the initial consent order. And so sometimes these matters can take
3 to 4 years.
a little while to reach a conclusion.
Any further discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Number 23 is case 2013015521. The complainant's family member passed away on July 15th, 2013, and the family tried to work out a plan with the funeral home for a payment plan for $950 as the family had no insurance at the time. Respondent states that they would discuss money later, and that the important thing was that the individual needed to get their family member's body to the proper location. The complainant states that they met with the funeral staff at 5 p.m. on July 16th, but none of the parties present introduced themselves as licensed funeral directors. Also, the complainant states that the family never received any sort of general price list in this case. We received no response from the respondent in this case, and we have a history of 2 closed complaints and 6 open complaints. And we're recommending a consent order with a $250 civil penalty for no response and authorization for a hearing.
Motion to accept, excuse me, council's recommendation.
Second.
Motion made by Mr. Hinkle, second by Mr. Starkey to accept council's recommendations. Any further discussion?
So they met with the funeral home at 5 o'clock, but nobody was licensed?
That's what the complainant was alleging, but this also, I believe, is related to the business relationship between the 2 parties in the previous complaint. So it seems related to that, and that's why we just recommend the $250. Yes.
Any other discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 24 is case 2013-015-691, and case number 25 is 2013-015-701. On July 16, 2013, the complainant's aunt passed away, and the complainant asked that the body be released to the funeral home of respondent number 24, believing that it was still under the current ownership that she was familiar with. Respondent number 24 failed to inform her that the establishment was no longer under the same management and had even applied to change its name. The manager for respondent number 24 instructed the complainant that the previous owner was still part of the funeral establishment and informed the manager that all of the paperwork was in place and ready to go, even going so far as to give the complainant the mistaken belief that the manager was speaking with the owner on the phone when the complainant and her father came in to meet with the manager. However, the respondent was actually speaking to the former owner's brother, who was respondent number 25 in this case. The complainant states that the respondent failed to provide her with a general price list and that the manager informed her that the pre-need contract would not cover the cost of the services by today's costs, when the complainant's father pointed out that the pre-need contract should have covered the cost considering they originally entered into the contracts in 2007. Respondent number 24 did inform the complainant that the original owner should have placed the money for the pre-need contract in a trust account, but that was actually never done, so respondent number 24 had no money to cover the services. The complainant eventually contacted the previous owner of respondent number 24 in the establishment and used the services of that individual and their new establishment. The complainant states that respondent number 25 offered to pay $2,000 to cover the cost of the services, and the complainant was happy with the services rendered and asked that action be taken against the new management of respondent number 24 and respondent number 5 funeral establishment. We received no response in this case, and respondent number 24 has a history of 2 closed complaints and 6 open complaints. And respondent number 25 has a history of 1 dismissed complaint, 14 closed complaints, and 2 open complaints. And in this case, we're recommending for respondent number 24 a consent order with a $250 civil penalty for no response and authorization for a hearing. And for respondent number 25, we're recommending a consent order with a $250 civil penalty for no response and authorization for a hearing.
Apparently, this is related to what we've looked at the last few minutes as well.
That's correct.
Motion to accept council's recommendation.
Second.
Motion made by Mr. Hinkle, seconded by Mr. Neal to accept council's recommendations. Any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 26 is case 2013-015-711. On July 1st, 2013, the owner of the respondent establishment passed away. A field representative stopped by there on the way to Nashville on July 29th, 2013, and found the establishment was closed. However, when he called the phone number of the establishment, the owner's son answered the phone. The son instructed the field representative that the family had no plans to operate the business at that time. However, when pressed as to what the establishment would do in the event that they received a death call, the son instructed him that they had access to a licensed funeral director who would handle his service if needed. We received no response in this case, and there's a history of 1 dismissed complaint and 6 closed complaints, and we believe that we're recommending that the proper action in this case would be to further investigate this case by a field representative to determine whether the establishment is currently being operated.
Motion to accept council recommendation.
It'll be $250 on top of the further investigation. Not responding.
Well, I think in this case, if we determine that they are
Violation.
in violation, then we'll
That'll
bring
be
it
at the
back.
time.
Yeah, we'll bring it back before the board.
Second.
Motion made by Mr. Hinkle, seconded by Mr. Neal to accept council's recommendation to determine whether this establishment is currently being operated. Any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 27 is case 2013-016-091. In this case, the complainant's husband passed away in September of 2011. The complainant is upset that her husband's casket was placed in a small room in the funeral home and was not in the chapel. Complainant states that an employee of the funeral home contacted the complainant to make her aware of something but would not tell her over the telephone. When the complainant made it to the funeral establishment, the employee took her aside to discuss selling her burial insurance, but then failed to provide the complainant with the correct pricing. Complainant is upset because the employee was explaining the burial policies to her, and the complainant was crying too much to be able to read the documents that she was signing. The complainant is upset with the way that the employee treated her in this case. In response, the respondent states that the employee asked to meet with the complainant to provide her with bookmarks and free items that they provide after funeral services. Respondent states that the husband was not placed in the chapel because he did not have a funeral service, but had a direct burial with only a limited time for the family to view. This was the choice of the complainant to save money that she needed for other obligations. The respondent gave the complainant a copy of the contract at the time of the arrangements. Since it has been since 2011 that the decedent passed away, the respondent states that one would wonder why the complaint is just now being filed, and respondent believes that it's likely that the complainant just attended a full traditional service in the chapel for her sister-in-law. We found a history of 2 closed complaints in this case, and we're recommending that this matter be dismissed.
Make a motion, we accept council's recommendation.
Second.
Motion made by Mr. Starkey, seconded by Mr. Neal, to accept council's recommendation to dismiss. Any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Number 28 is case 2013-016-721. The complainant states that they are a former employee of the respondent and have reason to believe that the respondents are working illegally in the state of Tennessee. The complainant states that they found that over the past 5 years, respondent has had a listing in both local phone books under the funeral home directors listing portraying themselves as a licensed funeral establishment, and also in the Yellow Book Director of Funeral Homes published by Nomis Publications. The complainant has come across the emorary.com and manta.com websites, also listed them as establishments doing funeral trade embalming, both ground and air shipping as well. On June 11th, 2013 at 3:28 p.m., the complainant received a phone call and text from the respondent giving him instructions to pick up a decedent who had passed away at the local hospital for Tri-City Funeral Home in Benham, Kentucky. The complainant was instructed to take the body to a local funeral establishment for the respondent to embalm, and that the complainant was instructed to leave a note informing the employees that this was a respondent's name call. In response, the complainant was employed for 18 months as an independent contractor only and never as a W-2 employee. The complainant had the responsibility of picking up and transporting bodies upon request and had no set hours and was one of several independent contractors employed by the respondent. Respondent and his wife are both licensed embalmers and licensed funeral directors in Tennessee, Georgia, and his wife is also a licensed funeral director and embalmer in Florida. During the time that the complainant worked with the complainant approached the respondent about assisting him in securing an automobile. Without advice of counsel, respondent agreed to co-sign a note to permit the complainant to purchase a vehicle. The vehicle was not the one used in the business, but was the complainant's own personal vehicle. The complainant failed to maintain insurance on the vehicle and fell behind on payments, resulting in the vehicle being repossessed. Due to this default, the respondent was forced to pay several $1,000s. The complainant then ceased to be an independent contractor and has represented to third parties that he is now working for a competitor in the removal and trade embalming business. The respondent provides body transportation services for the local funeral service. The Kentucky Funeral Home contacted the respondent about picking up a body at the hospital and embalming the body at a funeral establishment where the respondent has a pre-existing agreement. The respondent transports bodies and routinely provides the service for a number of funeral homes in the area. Respondent states that they maintain no standalone structure of their own and perform embalming services at local funeral homes by arrangement with such funeral homes. The complainant references respondents portraying themselves as licensed funeral home establishment, but the respondent states that this is simply not true. Also, nothing in the advertisements remotely provides an argument that the respondents were running a funeral establishment. In fact, respondent states that they advertise specifically that they do not provide contract service or sell any funeral goods or services at need or pre-need to consumers. We found no history of prior complaints, and we're recommending that this case be dismissed.
Make a recommendation, we accept counsel's.
Second.
Motion is made by Mr. Starkey, seconded by Mr. Neal to accept council's recommendation to dismiss. Is there any further discussion? All in favor say aye.
Aye.
Any opposed? Motion carries. Thank you, council, for your report today.
Thank you, Mr. President.
Chair will now recognize Robert Gribble, Executive Director for Administrative Matters.
Thank you, Mr. President. First thing to present is the licensee report. This is a report of license administratively approved by the Executive Director pursuant to the Board authority for the period of August 13, 2013 through October 7, 2013. You will see 3 new establishments, which is somewhat unusual. 2 of those being all of them funeral establishments, but one of them is a crematory. And also make you aware that Ms. Mosby and Ms. Johnson compiled a list of the crematories in Tennessee, and we've put that on our website and also emailed that to each of you. We now have 52, I think it is, crematories within the state, and that number seems to be growing each month almost. That's just information. The individuals are listed there that received their funeral director and or embalmer's license or both. The closed establishment report, there's one establishment that's reported closing since the last board meeting. That's Bulls Gap Funeral Home at 108 North Main Street in Bulls Gap, Tennessee. Disciplinary action report, that's the report of consent orders administratively accepted or approved by the Executive Director pursuant to the Board authority for the period of August 1, 2013 through September 30, 2013. And you have a listing of those with each one of them showing what the civil penalty was for each. Complaint report. For some reason, I don't think the second page made it to your iPad, so I'll be a little bit more detailed and be glad to answer any questions you have. This is a complaint report as of October 7, 2013. We have no complaints against apprentices at this time. We have 9 complaints against funeral directors and embalmers and 106 complaints against establishments, which make a total of 115 open complaints. President, that's my report.
Chair will entertain a motion to accept Mr. Gribble's administrative matters report.
Make a motion, we accept.
Second.
Motion made by Mr. Neal, seconded by Mr. Tinkle. All in favor, say aye.
Aye.
Mr. Gribble, will you talk to us about the approval of license applications?
Yes, sir. We have one individual to come before you today. Ms. Harris, if you will, come up and have a seat there. Either side of the podium is fine. Whichever place you'd rather say it. Either place is fine. Just one of the, no, go ahead and be seated. Just go ahead and sit down in the chair. This is Miss Rhonda Job Harris of Bartlett, Tennessee. She has a reapplication before the board for funeral director and embalmer. She's based on the reapplications, the board may, among other pertinent rules and statutes, specifically examine the applicability of Rule 0660-2-.023, which has to do with the 75%, and making a determination whether the applicant meets the requirements for licensure. Ms. Harris has been licensed by this board previously as a funeral director and embalmer. Just didn't feel like that I could administratively approve it since on her, whatever national board exams, her sciences, 74.7, which the board has historically in the past few years rounded that up to 75. But I still felt that there was something that needed to come before the board for your consideration. Has done the continuing education, met all the other requirements.
She meets all the requirements, other than that, the issue that we've had before, correct?
Yes, sir.
Motion to approve license.
Second.
Motion is made by Mr. Hinkle, seconded by Mr. Neal, to approve the license request of Rhonda Job Harris. All in favor, say aye.
Aye.
Any
Aye.
opposed? Motion carries. Congratulations, Ms. Harris.
Thank you.
Ms. Mosby will talk to you about further matters there.
There are no establishments that I'm aware of that need to appear before the board today for consideration.
Being no other business on the agenda for today, the chair will entertain a motion for adjournment.
Motion, we adjourn.
Second.
Motion made by Mr. Neal, seconded by Mr. Hinkle. All in favor, say aye.
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 Motion carries. Meeting is adjourned.